different venue. Mauritius or somewhere else would have been absolutely ideal, but these are difficult and challenging times that we are living in, and so we hope that this webinar will work for all of us, and that we can share some of our experiences and information about arbitration in our different jurisdictions. So welcome, and let's move straight into it. The way that we're going to do this is that our panelists will each do a short 6 to 7 minute presentation. We will do all of those presentations, and we will then have time for questions and discussion, and I hope that we'll have some lively and interesting discussion from the floor. So without further ado, let me introduce our first panelist, who is Dev Area. I'm not going to go into all of Dev's details, but he's a barrister at the Area Chambers in Mauritius, and he's been practicing in Mauritius since 1998. As you know, Area Chambers is the Mauritius member of LEX Africa. Dev has a very wide-ranging field of expertise, and I won't go into all of it, but amongst all of his areas of specialization, arbitration is certainly one of them. And so, Dev, if I can hand over to you, and if you can tell us a little bit about what is happening in Mauritius.
Thank you, Des, and good afternoon to everybody attending this webinar, and greeting from Mauritius first. As you know, Mauritius is also an international arbitration center. So without much ado, I'll go directly into that area of the law, whereby we have been conducting arbitration since the French time when they were occupying Mauritius. That was under our civil code. And then consequently, to get arbitration at an international level, we decided to introduce the International Arbitration Act of 2008, which is called MIAC. This law, as you will see in slide 1, introduction, it is based on the amended model law, and it is a very sophisticated piece of legislation which has been tried on several occasions. I will actually deal with one particular issue which is being developed in Mauritius and is causing a lot of difficulty here and in our Privy Council as well. And this is about enforcement of foreign arbitral award. We passed a law in 2001, which is a recognition of the enforcement of foreign arbitral award 2001. And that was to recognize and enforce a foreign arbitral award. In 2008, when we passed the International Arbitration Act, we also had a clause there in section 40 to recognize foreign arbitral award under the recognition and enforcement of foreign arbitral award. And ever since, we have a few enforcement which has taken place in Mauritius. I myself have been involved in 3 or 4. The most important one is how do you, when you are enforcing a foreign arbitral award, is it a straightaway process whereby your award will be enforced under Mauritian law, or do we have certain obstacles? A recent judgment in Mauritius held by the Supreme Court, which is the Betamax case. I will deal with that in slide 2. But before we proceed there, I will say that there is no automatic enforcement of foreign arbitral award under the Mauritian law. And section 39 of the Arbitration Act, which is explained in the second slide. Please, Anushka. Yes, section 39 of the International Arbitration Act, which I will call here MIAC, laid down the various situations whereby the court may not grant an award, an arbitral award in Mauritius when that is being sought to be recognized or enforced. So there are 5 or 6 grounds. I will not, they are on the slide, I will not deal with them, but I'll go directly to the next slide where it refers to section 39 2B2. So the court will not enforce a foreign arbitral award if that award is in conflict with the public policy of Mauritius. That is in our domestic law, MIA. So the judgment which dealt with the issue of public policy of Mauritius was canvassed in the case of Betamax, which is on the 4th slide. It is a state trading corporation and Betamax Limited in 2019. The case is about a contract of affreightment given to a local company to transport oil from India, and that was given in 2014. So in December 2014, there was a change in government, and the government actually terminated the contract of Betamax, and then Betamax went for arbitration in Singapore as per the clause of the contract. So Betamax won an award in Singapore, and they sought to enforce the award under Mauritian law in 2019. So when enforcing the foreign award from the Singapore court, our local court had to deal with the issue of whether that award does not infringe the public policy in Mauritius. And the court had to deal with the issue of whether it is international public policy which is of concern, or whether it is the domestic public policy which actually caused the obstacle for the enforcement of that award under Mauritian law. So after analyzing all the cases from an international perspective, our Supreme Court held that it is the domestic public policy which applies in case of enforcement of a foreign arbitral award. And in this respect, if that award actually offends the domestic law, so the court will not enforce the foreign arbitral award. There, the issue which they have to deal is whether that contract of affreightment was in breach of our local law, and if so, in what respect. So the court found that there was an illegality in the contract, and therefore, because of that illegality, the court could not enforce the foreign arbitral award in as much as the contract of affreightment was in breach of our Public Procurement Act. Consequently, the court did not enforce the award.
Right. That it, Dave. Thank you, Dave. Thanks. Thank you. Thank you very much.
I hope
the public policy issue is a very interesting one, and I think when we get back to some general discussion and questions, I'm sure there will be a lot of interest in what seems to me to be an important case. Thank you.
Sure.
Okay, so if we can move on to Kenya then, to Peter Gachui. Peter was admitted to the bar in 1990. He's a litigation lawyer, mainly in the field of commercial and civil litigation and arbitration. He is a fellow of the Chartered Institute of Arbitrators at the Kenya branch, and he has served on the Law Society's ADR committee for a number of years. So, Peter, over to you. We're interested to hear about the position in Kenya.
Thank you very much, Des, and good afternoon to all the attendees. The interesting thing about the Arbitration Act is that it has very similar sections throughout the jurisdictions that we practice in. The section 39 that Dev has just spoken about is almost in paramateria to our section 35 of the Kenyan Arbitration Act. Now, the Kenyan Arbitration Act, section 35, provides for the setting aside of an arbitral award where certain provisions of the act are deemed not to have been complied with. Those provisions that Dev has just set out on the issues of the arbitration agreement, whether parties are under incapacity or the arbitration agreement is void, or that the proper notice was not given on the appointment or the hearing, or the composition of the arbitral tribunal, and even the issues of public policy are very similar. And this section is of utmost relevance both to domestic and to international arbitrations, because where in an international arbitration, Nairobi is a juridical seat of the arbitration, then that section 35 would apply. The similar issue of section 35 is really brought up from Article 34 of the UNCITRAL model law. And you'll find, say in South Africa has incorporated Article 34 in its Arbitration Act. And you will find that the section 48 of the Nigerian Arbitration and Conciliation Act is the same. And it is the same as section 68 of the UK Arbitration Act. Now, the problem that has come up is that under the Kenyan section 35 Act, it does not provide what happens when a party is aggrieved by the ruling of the High Court. It is silent, which means it neither says that it is a final decision of the High Court, nor does it say that you can appeal from that decision. And it does not grant leave to appeal, as you would see if you look at section 68(4) of the UK Act. So unsurprisingly, what has happened in the Court of Appeal is that different conflicting decisions have come up over time. In some instances, the Court of Appeal has held that an appeal does not lie because there is no express provision under section 35 to allow an appeal. And in other decisions of the Court of Appeal, it has held that an appeal does lie for the simple reason that there is no express prohibition of it under the Act. Now, the two petitions that have ended up in the Supreme Court arose from the Court of Appeals declining to hear the appeals from the High Court decision. The High Court in the two appeals, which I will prefer the citations at a later stage, by a majority decision held that an appeal actually does lie from the decision of the High Court, and that such appeals should be allowed, but only in special circumstances. As a lawyer, you would know special circumstances is really the gateway to all forms of circumstances. But what the Supreme Court has settled is a contentious issue as to whether an appeal lies from a section 35 application to set aside. The reasoning of the Supreme Court is that section 35 provisions do not question the merits of the arbitral award. both as a matter of fact or as a matter of law. What the Section 35 provisions are for is to look at the process by which the arbitrator arrived at the decision. And that process is whether there are incapacities of the claimants or any of them, or whether there has been a breach of public policy, so that it contains the High Court to the issues relating to Section 5 strictly and not to any other provision of the law. And therefore, the issue that mostly has been happening is that the High Court has been treating itself as if it is an appellate court from arbitral decisions. And with this law now having been settled, we hope that there will now be no more judicial activism in setting aside arbitral awards merely because of going into the facts of what the arbitrators held. Now, the two decisions took 10 years from the time the arbitral award was made to the decisions that were delivered by the Supreme Court in December last year. And the journey is not over yet. They are back to the Court of Appeal to determine the merits of the applications. So where are we then? Has the Supreme Court expanded judicial intervention? And has it also expanded the timelines within which arbitral awards are to be contested? If it's going to take 10 years, then it defeats the whole purpose of why parties go to arbitration in the first place, because you don't want to be set up to be in court for such a long period of time. But we hope that the High Court will take cognizance of its limited powers. The other issue that the Supreme Court said is that Section 35 needs to be looked at to provide for a proper mechanism by the legislature, so that it is not only an issue of leave through exceptional circumstances, but we need to amend our act so that it is quite clear that if you do have leave, then you are entitled to go to the Court of Appeal, and you may eventually end up in the Supreme Court. Who knows? And that's a long length of time. But in the meantime, I have looked at the COVID-19 situation, and as tragic as it may be, what it has done is that it has really accelerated the use of technology and virtual hearings, so that we are at a position where we probably should be in 5 years to come. Now, if we take advantage of the virtual communication as we are in this webinar, we may probably be able to speed up the hearings in the arbitral tribunal and in the courts, and probably compensate for the time that will be lost through the appeal process and the hearings. So that's where we are under Section 35, and it is still something to be looked out for. Thank you very much.
Thank you very much, Peter. Raised some interesting issues there, and I'm sure we will come back to those as well. And we now have Shabir Latif. Welcome, Shabir. We hadn't spoken earlier. It's had some difficulty getting you here today, but welcome. Shabir is the senior partner in the firm of Skrani Gao in Malawi, and has been a legal practitioner in Malawi for more than 30 years, and was appointed senior counsel in Malawi in 2014. And amongst various other specialized areas of practice, he is also interested and specialized in arbitration. And so let me hand over to Shabir. Shabir, if you can just unmute yourself there. At the moment you are muted.
Good afternoon to you.
There we are. That's it. Thank you.
Okay, good. My apologies. We had a technical issue at this end, but we're online now. Arbitration Act is the principal statute in Malawi. It's an ancient legislation by comparison, has not been updated at all, except by various legislation in Malawi. We've got some supplemental legislation through our colonial association, which actually is quite helpful, the British and Commonwealth Judgments Act, which provides some guidance on enforcement of various provisions of the Arbitration Act. We, unfortunately, for reasons unknown, Malawi has not adopted the UNCITRAL model law. And Malawi is neither party to the 1958 New York Convention nor the OHADA Convention. Having said that, the Arbitration Act works quite well in Malawi. Although we don't follow Scott and Avery case, the UK case, nevertheless, Section 6.1 of the Arbitration Act gives Malawi courts discretion to stay proceedings and uphold arbitration clauses in contracts. One of the things that the courts look at is that particularly when there's a dispute between parties and one party resorts to litigation and does not resort to the arbitration clause, the respondent, the defendant, is entitled to go to court and apply for stay of proceedings. What the courts require under Section 6.1 of the Arbitration Act is the defendant does not participate in litigation. What the defendant has to do is, the first thing the defendant must do is simply make an appearance and dispute the jurisdiction of the courts and apply to the court to stay proceedings. And what the courts look at is, one, has the defendant put in an appearance and not participate in the proceedings? Secondly, is the defendant willing and able to participate in arbitration? Thirdly, does the contract provide for arbitration? And the court will actually exercise its discretion in enforcing arbitration. Just 3 weeks ago, I had an issue. There's a case called Kaka Construction Company in Fargo. I was acting for the defendant, and we applied for enforcement of the arbitration provision in the contract, in the court state proceedings. So in that respect, the courts now have given a clear guideline as and when they'll enforce that. So that's one of the biggest development in arbitration in Malawi. The second thing is on the enforcement of awards. That again has worked quite well. The procedure for enforcement for both domestic and foreign arbitration awards in Malawi is similar to enforcement of a local court judgment. Now, a foreign arbitration award made in the United Kingdom can be registered by registering the award in the Malawi High Court. Once registered, that foreign arbitral award may be enforced with the leave of the court in the same manner as local judgment. Whereas any other enforcement award does not actually automatically be enforced. Now that's because of the British and Commonwealth Judgments Act. So the trick is when you enter into contract, your arbitration proceeding as far as Malawi is concerned ought to be English arbitration proceedings. So, you know, your jurisdiction should be LCIA, ICC, Paris, London, UK. And all you do is once you've got an arbitration award in the UK, yeah, all you do is register it in Malawi, and it works quite well. Now, if you decide to have an arbitration enforcement proceedings under South African law, or you have AFSA, yeah, as opposed to seat in Johannesburg, then you've got to re-register and sue a local party. So that's the game that you've got to play. And it, it works quite well. So you simply say arbitration award, LCIA, ICC Paris, or any dispute resolution under the UK law. Or you say arbitration proceedings, Malawi law, and then you can have arbitration in AFSA, South Africa. And again, that works well because your assets are going to be in Malawi. Thank you, ladies and gentlemen.
Thank you very much for that, Shabir, and we'll certainly get back to that in question time. And our next panelist then is Sydney Chisenga, the managing partner at Corpus Legal Practitioners. Sydney is the head of the dispute resolution department, 15 years of experience, and he handles a lot of major commercial litigation work and arbitration work in Zambia. So Sydney, let's hand over to you without any further ado.
Thank you so much, Des, and good afternoon to all the attendees. And I'd like to thank LEX Africa for arranging this webinar. I'll go straight into talking about arbitration in general from the Zambian perspective. As you'll notice, most of the provisions, I think across Africa, in terms of arbitration legislation, are quite similar in terms of enforceability and how you can set aside the arbitral award. So in Zambia, the enabling legislation is the Arbitration Act number 19 of 2000. And this act is supplemented by the Arbitration Court Proceedings Rules of 2001. So the substantive legislation in terms of what pertains to arbitration is contained in the enabling legislation, which is the Arbitration Act. Then in terms of procedure, we follow the Arbitration Court Proceedings Rules. So these are the rules that establish how you can register an award and how you can apply to set aside an award. Now, some of the features of the Arbitration Act in Zambia are similar, I think, to Kenya and a bit similar to Mauritius. There's a difference, of course, with Malawi because I've noted from Shabir's presentation that in Malawi, the UNISTRO model law is not recognized. Now, the Arbitration Act in Zambia annexes the United Nations Commission on International Arbitration Law model law. So we have a statutory recognition of the UNISTRO model law as part of the law in Zambia. Now, it's applied twofold to some extent, and it's read together with the substantive provisions of the Arbitration Act. Now, the model law applies in Zambia if the place of arbitration is in Zambia, subject to the other provisions of the Arbitration Act. Then where a place of arbitration is outside Zambia, then there are specific articles which are highlighted. That's Article 8, Article 9, Article 35, and Article 36 of the model law applies. Now, what is interesting is in addition to annexing the UNISTRO model law, in addition, the Arbitration Act also has given statutory recognition of the New York Convention. So all the awards under the New York Convention are recognized and are enforceable in Zambia. Then generally, in terms of other arbitration awards, they are binding irrespective of the country in which they are made. Now, in terms of enforcement, there is provision under Section 18 of the Arbitration Act that in order for you to enforce an arbitral award, you need to make an application to register the arbitral award in the High Court. before the registrar of the High Court. So once the arbitral award is registered, the effect is that it has the force of a judgment, just like in most African jurisdictions. So it assumes that it has a force of a judgment, and you can enforce a registered arbitral award, just like a High Court judgment. Now, in terms of challenging of arbitral awards, there is provision under Section 17 of the Zambian Arbitration Act, where under specific grounds, one of them is similar, like in other legislation in Africa, there are specific provisions which relate to whether the composition of the arbitral tribunal was in accordance with the agreement, then also whether a party to the arbitration agreement was given adequate notice of the arbitration. So there are several grounds upon which the arbitral award can be set aside. And usually the legislation gives a window period of 90 days within which someone can apply to set aside the arbitral award. So those are some of the features. Now, in terms of, quickly in terms of developments, new developments in arbitration law in Zambia. Now, in terms of the disputes, if we look across the spectrum in Zambia, we've noticed that there's very high level arbitrations in Zambia that are involving the state and investor disputes. Now, mostly these can be tied to past undertakings, pre-investment undertakings that the state made to these entities. And after a prolonged period of time, and obviously because of the changes in government policy, you find that there's been an abrogation of some of these investment agreements that the state was a party to and that agreed to fulfill. So this is the main feature of high-level arbitration right now. It involves state and investor disputes. And obviously, for our country, this may not be desirable because it has an effect on foreign direct investment. Then we've seen, because of the COVID situation, there's been a level of increased shareholder disputes. So this is one of most of the arbitrations that we've been involved in involve a lot of shareholder disputes. They've increased over time, especially in the last maybe 6 months. And most of it can be tied to the effect of COVID-19. Then in terms of desirable mechanisms for dispute resolution, most investors, of course, continue to prefer arbitration other than national courts for obvious reasons. It's confidential, and most of the arbitrations, involve very sensitive information such as trade secrets, and it still remains a favored avenue of resolving most of these disputes. So that is the brief development in terms of arbitration law in Zambia. Thank you, Des.
Well, thank you very much. Thank you for that, Sunisa. Are we going now straight on to Stanley's? Is Nigeria? Right. Is he on? Michael, I believe you are on mute. Can you just unmute yourself, Michael, the Don in Nigeria?
Okay.
There you are.
Can you hear me now?
Well, yes, welcome. Welcome. We're glad that you are with us.
Yes.
Welcome. It's good to have you here. Michael is the managing associate in the litigation department at the Giva's RG firm. And he's going to tell us a little about arbitration in Nigeria. Michael, over to you.
Yeah, thank you very much, Des. Good afternoon, everyone. We go straight into the sources of law for arbitration in Nigeria. There are two main sources of law relating to commercial arbitration in Nigeria. The first is the common law and the doctrines of equity, and the second is statute. The principal statute governing commercial arbitration in Nigeria is the Arbitration and Conciliation Act 2004, which consists mainly of the provisions of the UNCITRAL model law. And furthermore, we also have the New York Convention, which Nigeria is a signatory. And this is basically based on reciprocity. Nigeria usually recognizes awards from countries that also recognizes Nigerian awards. Furthermore, we also have the various rules of the high courts in Nigeria. They also recognize foreign awards. Also, under the ICSID rules, any award from the ICSID can be deposited with the Supreme Court of Nigeria and registered as such, and it will be enforced as a judgment of the Supreme Court of Nigeria. Also, any foreign award can also be litigated upon in Nigeria by bringing it to a Nigerian court to institute an action. And the court will enforce it as a judgment of that court. So these are the rules that govern the recognition of arbitral awards in Nigeria. And as relates to developments in Nigeria, many of the rules, of course, are now encouraging the use of arbitration rather than the formal dispute resolution mechanism of litigation. Because as it is, many of the court rooms are congested with cases, and it takes a lot of time and resources to resolve such disputes. So basically, the new development is that the rules of courts are encouraging parties to seek other alternative dispute resolution mechanism, of which arbitration is the main mechanism which parties are encouraged to explore. And under the new Lagos Multi-Door Courthouse Act, the Chief Judge of Lagos State is mandated to appoint 3 judges of the Lagos High Court to act as ADRO judges to encourage parties to seek alternative dispute resolution instead of litigating. Similar laws have been replicated in the various high court rules of the states in Nigeria presently. Presently as it is. So, as it is, the use of arbitration is on the increase in Nigeria. Parties are being encouraged to use arbitration instead of litigating, and the enforcement of arbitral awards has also been made easier. All you need to do is either you bring the action to court, the awards to court, institute an action on it. If it's exceed, you deposit the award with the Supreme Court, and it is enforced as a judgment of that court. If it's a country with which Nigeria has reciprocity of recognition of arbitral awards, recognition is also accorded such states. And also member states to the New York Convention also are accorded recognition, basically. Thank you.
Thank you very much for that. That was very interesting as well. That brings us then to our final panelist, and he happens to be sitting here with me, Stanley Nyamahindi, and Stanley will tell you more about. Stanley is the CEO of the SADC Lawyers Association that a number of our Southern African members will certainly know about. and he is also the vice chairman. I chair AFSA's SADC division, and Stanley is my vice chair, and in that capacity, we've been working fairly closely together over the last year or two, Stanley, building up this initiative. So Stanley will just tell you more about what's happening more broadly in the Southern African, in the SADC region. Stanley, over to you.
Thank you very much, Des. I think the most important thing is welcome to the last two slides of this presentation. And I'm going to just, ladies and gentlemen, introduce you to the most concrete steps that the SADC region has taken in order to institutionalize the practice of international commercial dispute resolution here in the SADC region. And of course, the beginning of this is with the enactment of the International Arbitration Act in South Africa, which laid the foundation for the arbitration, Arbitration Foundation of Southern Africa to lead this initiative in SADC. And of course, it is very important to note that the foundation of this work was the recommendations by the Law Reform Commission of South Africa for the adoption of the UNICITRAL model law. And you will see there the statistics that South Africa was the 11th to join this. And in SADC, we generally have 5 countries that have adopted. And we will be looking at increasing this number. What is also important to note is that on the back of this framework of legislation, we were able to then adopt what is called an agreement or a memorandum of understanding between the Arbitration Foundation of Southern Africa and the SADC Lawyers Association, which to me represents a very serious commitment to advancing the practice of commercial arbitration in the SADC region. And it really brings together under an institutionalized and coordinated framework, business associations, chambers of commerce, trade associations, and professional associations from the legal to the accounting, engineering, etc., that then become able to coordinate the dispute resolution under a certain set of rules. If I go to the next slide, I'm just going to outline what the objectives of the SADC division are. And the first one there is commitment to the development, strengthening, and enhancement of commercial alternative dispute resolution practices. This is modeled on AFSA's services in the SADC countries, and this is by way of the joint initiative that I referred to under the MOU between AFSA and the SADC Lawyers Association. It is very important to note that a key step in materializing this goal is the establishment of a SADC panel of arbitrators and mediators. This is wherein we make sure that from each country, there is an equal number or a substantial number of experts with the adequate expertise through a set criteria that are able to handle the cases for arbitration in the region. This is also done based on the adoption of a standardized set of rules. Those of you who will have or who have had the privilege to go onto the AFSA website, you will see a link to the AFSA international rules that actually being adopted or have been adopted and are available for you to be able to see exactly how we intend to take this initiative forward. And we also then have an administering secretariat to handle the cases of arbitrations and mediations, as well as dissemination of information to various stakeholders that I've outlined above. The provision of training throughout the SADC region and joint involvement in conferences and seminars is very important. We deem that the standardization of rules, the institutionalization and harmonization of the practice of international commercial arbitration in the SADC region is very much founded on the ability to create an adequate pool of skills in the SADC region. So in the end, we seek to lead advocacy and the strategy for partnership with state and non-state actors. Now, just to break that down a little bit, the state actors will be your government, your SADC regional economic community at the governance level. And we engage this in order to combine the private initiative and its international standards through recognizing a uniform set of rules in SADC. Now, in long and short, this is what I can say that our initiative is about, and I will leave the rest to our question segment.
Right, let me get back in the picture. It was Stanley speaking, not Des Williams. So, well, that ends the formal presentations, but what I would like to do now is to just open this to questions and discussions and comments from anybody out there. I think a number of interesting issues have been raised, so please, Lishka, you let us know if there are any questions coming through. Perhaps just to get the ball rolling here, if we can possibly kick off just with the other panelists. Dev had spoken about the public policy issue in relation to enforcement, and I do think that that is an interesting issue. I know that in South Africa, way back, still under our old 1965 Arbitration Act, there was the well-known case of Crock and Jones, and the public policy issue in that case, when it came to enforcement of an international award, was whether it was against public policy to enforce a US damages award for punitive damages. We all know how you get US courts awarding massive punitive damages amounts in big claims. And the South African court said that's contrary to South African public policy. And that kind of award would not be enforceable in respect of the punitive damages part of it. So the rest of it is enforceable, but to the extent that there were punitive damages involved, it was not enforceable. And I'm interested to know, just in other jurisdictions, whether you have similar issues arising when it comes to public policy issues. Dev mentioned the one about procurement policies, which I think is very interesting and relevant in a number of African jurisdictions, and I'm sure there must be other examples.
Well, in Kenya, public policy, we have said, is like an unruly horse. You may ride it, but you never know where you will ever get to. So it really becomes a hot contentious issue when, especially when courts invoke the public policy as a last resort to rescue or kill an arbitration award. And it's quite interesting. There are matters pending in the Court of Appeal as to what governs public policy. But in procurement law, we do agree that where there are serious breaches and enforcement provisions, then public policy can be invoked.
Yes, it's an unruly horse indeed. Other contributions from panelists, or any questions from anyone else out there?
If I may, Chair, as regards public policy, when it was dealt in the case of State Trading Corporation and Betamax, to which I referred earlier on, unfortunately, I did not provide a whole copy of that judgment before. The Supreme Court of Mauritius actually made a very interesting international comparative description of public policy in different jurisdictions, starting from the US, Europe, mainly the UK, France, and then goes to India, Australia, and other part of the Asian countries. But then they did not go to Africa at all. The judgment itself provides a very good analysis of public policy in different jurisdictions, mainly common law and civil law. And when it comes to public policy, it would appear that under the civil law, namely French, and I believe it would be the same in civil law African countries, public policy is a very restrictive approach. It is a very restrictive approach, and the court will be more like pro-enforcement bias in those countries. In the common law jurisdiction, like Mauritius, which is hybrid, they will look at the national public policy. However, we have not, unfortunately, we don't have anybody from the French jurisdiction here, or even Francophone jurisdiction. But I have a judgment from the French Cour d'Appel, the Court of Appeal in France, whereby they deal with an arbitration in the Republic of Congo in relation to the same issue as the STC case of Mauritius for public procurement. And there, the Court of Appeal, which overturned the decision of their equivalent of High Court, they say that where there is corruption, for instance, okay, so that would be a ground for intervening, and they will not enforce the judgment when there is corruption. So in that case of Congo, there was corruption, so the Court of Appeal in France, they actually did not enforce the award. Similarly, under the same jurisdiction in France, dealing with a case or a banking case where a bank was purchased by people from Latvia, the court says if there is fraud, that will be a matter of public policy, and the court, although France is pro-enforcement bias, they will not enforce an arbitral award if there is fraud. So to sum up, public policy has got different elements and components. It may be a illegality, where, as in the case of Mauritius, the contract of affreightment was in breach of the Procurement Act. So that is illegality. So under French law, corruption and fraud will amount to public policy as well.
Okay, thank you, Dave. Anyone got anything to add in relation or further questions on that issue, on public policy issues, which I think it's the kind of thing that one could spend an entire, you could have a webinar entirely about public policy issues. So it's interesting. But other important issues that any of our panelists specifically would like to raise? Sydney, yes.
I think there's one very interesting case which we hope to share at some point. We are involved in this case. It's a very high-level case which involves a situation where there is an arbitration agreement and one of the parties decided not to proceed by way of arbitration, but instead filed a winding up petition against one of the parties to the arbitration agreement. Now, this case has gone all the way to the Court of Appeal, and what will be interesting is what the Court of Appeal will rule in terms of the efficacy and whether they will give effect to that arbitral clause, which should have been invoked. So it's a very interesting development that we will share at some point when the judgment has come out. It will definitely improve the jurisprudence and settle the position in terms of whether parties to an arbitration agreement can circumvent the dispute resolution mechanism and seek an alternative one, such as a winding up petition. So it's a very interesting development.
Well, we'll look forward to hearing more about that one. I think it's an important and interesting case, and so we will look forward to seeing how that is ultimately dealt with. Any other specific issues? If not, perhaps I can just raise, I think we do have just a little bit of time left here. And I think an important issue that none of us have really touched on at all is the question that one does hear a lot of discussion in African arbitration circles about more African involvement at the arbitrator level and at the seat of arbitration level where African parties are involved. And I know that you know, Peter, for example, I think you might know Edward Tallball, who's a retired Kenyan judge, and he is very active on the international arbitration circuit, and he has been speaking a lot about this issue. Why is it that often in parties involving, in arbitrations involving African parties, and sometimes where parties on both sides are from Africa, but disputes end up being arbitrated in London or in Paris or in Geneva? And the question is, why is that happening? Do we have ourselves to blame for this, or that we are in Africa losing some of that work to those other jurisdictions? What is the root of the problem, and how do we go about directing that? So I'd like to just have some other views from our panelists.
This is a biggest problem that we face in Malawi. And first it comes in from integrity issues from investors themselves. They will usually insist that if there is a arbitration between a foreign investor and whether government or local company, then a national of the country cannot sit as an arbitrator. That's a standard thing that is coming out. Secondly, the problem comes in from issues that have happened in Malawi, that Malawi does not have an arbitration forum, specific arbitration forum. Usually, we get the Malawi Law Society or the Institute of Chartered Accountants in Malawi to nominate the president to select an arbitrator. And that is the biggest problem. We are addressing this issue. And hopefully by next year, we will have a permanent secretariat and arbitration forum. And the retired judges, Supreme Court judges who will have retired, so we will have a pool of arbitrators. Hopefully that might give it some confidence. In the meantime, I think integrity issue is when you have an international investor, you prefer LCIA, ICC as an automatic source which can actually act as an arbitrator, not even AFSA because of the legal issue we have in terms of. So that's a specific problem in Malawi.
Yes, thank you. Yeah, that's an interesting insight there. Michael, just in Nigeria, I know, for example, that this is an issue in Nigeria, is that there's often a view in Nigeria as well, why do arbitrations involving Nigerian parties almost inevitably or often end up in other or seated outside of Africa. And I think the point that Shabir has been making here is that often, obviously, if you're looking at international investor situations, those international investors will often not be African parties, and they will insist on something like ICC or LCIA. But that's not always the case. Sometimes you have situations where both parties are African and matters still end up outside of Africa with international arbitrators, not African arbitrators. But Michael, do you want to maybe give us a view from
Yes. Yes, I think basically the problem has to do with the arbitration clause itself. When you are drafting your agreements and you make English law and you put the venue there as London or Paris, definitely African arbitrators are disadvantaged because an African arbitrator cannot go to Paris and apply French law. So African contracting parties, it behoves them to insist, especially when both parties are Africans, to insist that the law of that particular country should apply, and also the sitting of the arbitration should be in Africa. In that way, African arbitrators will have a larger role to play. But when ab initio, the arbitration clause takes everything out of their hand, I think it's rather unfortunate. So the way to go would be to encourage African contracting parties, more so when they are both Africans, to insist on applying African laws, and the seat of the arbitration should also be in Africa. I think that will sort it.
Okay, thank you very much, Michael. Yes, I see we have a question from Yvette Leroux, who asks, for interest's sake, why do parties have a problem with a member of AFSA to arbitrate a matter? Why do investors prefer arbitrators from ICC or other institutions? Let me just very briefly comment on that, and then I might ask Stanley as well to come into this. Obviously, one of the important things that we've tried to do with this AFSA SADC initiative is exactly that, is to say a dispute involving parties in Southern African jurisdictions, it makes sense for it to be dealt with on a regional basis rather than on an international basis. But the question does remain, and it's a point that other panelists have touched on, is where you've got non-African parties, often the insistence will be on ICC or LCIA. But Stanley, do you want to comment?
Thank you very much, Des, and thank you very much, Yvette, for raising that question, because it speaks to the mandate of AFSA and exactly why it was set up, in order to provide a credible institution that will develop the talent that is required, the expertise that is required to handle international arbitrations here in Africa. And once you bring this up, you come to the next level of what my presentation really was, which is to say, there is AFSA, so what? And what is in it for everybody who is in Africa or anywhere else in any other part of the world? And the real issue is that it provides this credible alternative. It is a foot in the right direction in order to create the expertise that we need in order to handle international arbitrations. And as law firms, as commercial institutions out there, our call to you is to include our clause in your commercial arbitration and contracts as you transact, because this is the foot in for African arbitrators. It's not only for AFSA, but there are many African and credible initiatives for international arbitration in the continent, and we have to give them a chance through the clauses that are in our contracts. At the AFSA level, there's also a strong initiative to capture young arbitrators, which gives opportunities for the young lawyers and also for the senior lawyers as mentors. And the young lawyers can get this experience and exposure, because if we do not grow it from a young age, then obviously we are setting Africa back quite a number of years in becoming consistently competent with the other international centers. So I believe and would like to end my presentation there. Des?
Good, thanks very much. I mean, obviously, if you look worldwide, there are important regional arbitration centers that have developed very successfully in places like Singapore and Dubai. And certainly in Africa, I know there are East African initiatives, there are in Nigeria and West Africa generally, there's the Cairo Center. All of those centers are important regional centers, and we should all in our different regions be encouraging our clients to engage with those organizations and to use those regional organizations wherever they might be, rather than taking arbitrations out of Africa. I know organizations like the ICC, for example, are certainly very aware of the fact that, and getting the message across, that you can seek an arbitration wherever you want to seek it. It's entirely up to the parties. If you want to seek your ICC arbitration somewhere in Africa, there's absolutely no reason why you shouldn't do that and still have ICC rules applying, for example. An ICC arbitration does not have to be seated in Paris or Geneva or London. And the position, I'm sure, is the same with a number of other reputable arbitration organizations. Other comments at all from panelists or anyone else out there? Let's just see if we have.
If I may, there's just one comment in relation to your question, why it is not Africa, and then to answer to Sabia also. I think what we have to do for Africa, well, this has to be done at higher level, political level, not our level, is what we did in Mauritius, which was not an international arbitration center, but then we had to invest massively in terms of finance and other means. What we did actually, when we introduced the MIAC, which is the International Arbitration Act, we actually sought advice and got a lot of assistance from LEAC, okay? And then we work extensively with ICC, whereby one of our country fellow men was also very involved, Mr. Mulan, Salim Mulan. And we also get a lot of help from the PCA. And eventually we tied up close relationship with LEAC and PCA until recently LEAC left, and then we are still with PCA. I think that connection bring a lot of confidence in our Center for Arbitration and also our local law, which is MIA. I think this is what needs to be done in Africa. Either this is being done at the African Union level, whereby we have a set of rules for Africa, tailored for Africa. I believe we have very good arbitrators in Africa. And if that is led by the African Union, as they are doing for international tax law, where I'm also involved, in relation to exchange of information on tax matters for income and revenue, not to leave Africa. I believe if we do that at that level, I'm pretty confident that we will get a very good African arbitration center in Africa for Africa, because as Sabia rightly said, they insist on not having somebody from that country, namely Malawi, to sit as arbitrators. But then what they forget is the main investment is, I mean, the LEX situs is Africa, or is a place where the investment is being carried out. So it makes sense that the law of that country or the arbitration rule of that country should normally be chosen. And I think it is very unfair to continue and insist on foreign arbitration rule when something is done domestically.
Thanks very much.
Yeah, maybe if I could quickly comment.
We have a question from Kami Govinda. I think the main concern from international investors is whether African arbitrators are able to arbitrate on behalf of the parties if the governing law is English or French, for example. Are African arbitrators also English or French law qualified to arbitrate if the seat is in Africa? Well, previous panelists, I think, have touched on that issue. Obviously, the choice of law issue is an important factor, does influence things, because I know that in a number of African commercial contracts, the law that is applicable will often be English law, and that does influence things when it comes to the decision, and it often leads to then an English QC being appointed as the arbitrator in the matter. But I think the message that we need to start getting across to everyone is that we do have arbitrators in Africa, in a whole number of African countries, who are English law qualified, who have some English law background, who certainly would be able to act as arbitrators in English law matters. And Deb, I'm sure the same can be said in relation to French. Certainly in Mauritius, there would be arbitrators who would be able to do both French and English law arbitrations. So although it is an issue, I don't think that it's an insurmountable problem by any means. Any other comments from panelists?
Yeah, if I may add, there's the question, there is a choice there. It says English or French law. I think that should not be a problem, because if the number of arbitrators is more than one, then the party can choose one from the common law African countries and one from the civil law African countries who will speak French. I don't think that should be a problem in any event.
I think that's right. And you know, another point is that it's quite possible to have an arbitrator who does not have a background in relation to the particular legal system. And so, for example, I have certainly had arbitrations, including ICC, where South African law applies, but you'll have an English QC as the arbitrator. Of course, what it does mean sometimes is that there may then be a need, if it's a difficult or complex or unusual legal point, you might need some expert evidence in relation to the law. But most experienced commercial arbitrators from a common law background are going to be able to deal with something, whether it's English law or whether it's South African law or whether it's the law in Kenya or whether it's the law in Zambia. A good commercial arbitrator will be able to deal with those issues. And you don't have to have qualified or practiced in that jurisdiction in order to be able to deal with a matter that might be governed by that law.
If I may, I entirely agree with you. Even if the arbitrator is not English qualified, that doesn't mean that the arbitrator is incapable of adjudicating over that arbitration. I'll give you an example. I've been an expert witness on Zambian law in an arbitration in Lagos at the Lagos Center of Arbitration, where I've gone to give expert evidence, and is adjudicated by a Nigerian arbitrator, and the award was properly written. So for me, it's more of not whether the arbitrator is English qualified or not, but I think we need to look to, regional arbitration bodies. And I like the initiative that you are doing, so that we are able to sort of lobby, even, for instance, our governments when they're entering into these investment agreements, for them to insist that since the arbitration is in Africa, then the arbitral bodies in Africa should be the ones that appoint either the arbitrator, or they insist that we have credible institutions right here with qualified arbitrators who can adjudicate these arbitrations.
Right, well, Stanley is certainly going to be doing that with the SADC members. So the SADC countries' law society, Stanley will...
And the African Union as well.
And the African Union as well.
Could I possibly throw in a political angle to all this? It is we as lawyers who advise our clients on these arbitration clauses. And we do also advise our governments. So probably it begins with us. We are our own worst enemies. We are the ones who insist and advise our clients that even though you are a South African investor coming to invest in Kenya or Nigeria, you select the arbitration clause to be ICC, UK, or France, or wherever else? Is it that we do not have confidence in our own abilities? Is it that we do not have confidence in our own competence? And I think, just as you're saying, with the SADC and the development, we have already come a long way. Most African countries are doing 30, 40 years plus since independence. And it is time that we reflected on these issues seriously. When we have a Mauritius Arbitration Center, we have the Kigali Arbitration Center, Nairobi has set up an arbitration center, Lagos has set up an arbitration center, and to go elsewhere.
Think in those terms.
Yes,
it's unfortunate, but that's right. Yeah.
Shabir, do you have a comment? Sorry, you're on mute.
Myself. I think the difficulty, Des?
Yes.
Jim, I think the difficulty is going to be when you're sitting there. I mean, we have a client, for instance, sitting there. It's actually a foreign government dealing with huge investments in renewable energy, which is what we've been doing for the last year or so. And the question they're going to look at is what is in their interest. And their interest is going to be what is the best forum for them. They're not going to look at educating or African or things like that. And they're simply going to say, okay, if we have LCIA, we'll be able to enforce it without any difficulties. I think that's the sort of thing they're going to look at as such, because it comes up with the reputation, it comes up with the confidence. We'll get there someday. And I think Stanley's got a lot of work to do, right? But at some stage we'll get there. We've got to start somewhere. But I think talking about educating our clients and saying that, well, we should have this in Malawi, it doesn't work. At the end of the day, you look at your client's interest, yeah? And if your client is CDC, you know, CDC Capital Partners or FCD from, you know, FCD from America, you're going to look at from the client's perspective, from your client's perspective and interest, and what is best for them. And I think that's the reality.
Shabir, you're 100% right, obviously. And I mean, obviously, where one's in a commercial negotiation and you get to talking about the arbitration clause, if your country is not even party to the New York Convention, there's not much point in taking the discussion any further, because any international investor is told, okay, well, your country acceded to the New York Convention. That's no good. And I think South Africa with the New York Convention, that has been part of the game for a long time. But until just 3 years ago, we still had a 1965 Arbitration Act that was hugely outdated. And that would be a very difficult sell to international parties to say, well, don't worry about it. We've got this 1965 Arbitration Act, and the courts are constantly interfering in arbitration. All of that has changed now. But obviously, there's a lot of marketing to be done on that, and one needs to sell and satisfy those investors and other international commercial parties that we are all now on board with internationally accepted and acceptable standards in arbitration law and practice and procedure, and that we've got the organizations that can support all of that as well. Anything else? Any other contributions from anyone there?
If we are still with time, I would just want to add something in relation to MIAC, whereby under our law, the MIAC law, you will know that most of the companies using Mauritius to invest into other parts of the world, namely Africa, they use a company called Category 1 Global Business Company or Global Business Company. So under our MIAC, there is a provision there where if you're using a global business company, you are bound to have in your M&A or constitution, as we call it under Mauritian law, a provision that any dispute in relation to that company or any contract in which that company is involved is to be by arbitration. So that was inserted mainly to encourage people to use the Mauritian Arbitration Center. So if you go by that section of the law, all companies which hold a global business license and which are investing, say, for example, in Africa, are bound by our local law to use the Mauritian arbitration rule and Mauritius as an arbitration center. But the problem is, this is the law. But when it comes to arbitration, I have not seen, or I have seen very few contract whereby Mauritius is the situs or the law for arbitration. And in a way, I did write an article and canvass the issue with the government. This is arbitrary because arbitration is an agreement between parties. So you can't have a law to force global business companies to use the Mauritian Arbitration Center or the Mauritian Arbitration Act. The point is, we have a law which forces you to use our MIA, but the problem is investors are not using that. They will choose the law which is, I will not say in their favor, but which suits them best because the investment is in their hand. Obviously, as Sabia and yourself said, they would want to have the best of it. So the point is, although you have a law which forces you to use a local law as arbitration law, the investor will not do that.
Yeah, I mean, the interesting thing I think in South Africa has been that we got the new International Arbitration Act in late 2017. So AFSA's international division was only established, I think, around probably about April or so of 2018. And there are now, I think it's in excess of 70 active international arbitrations in the AFSA international division. So that's been remarkable growth over a very short period. And you say, well, why has it happened? To some extent that has happened because there were general AFSA clauses in a number of commercial contracts already. So when those were in agreements whereby the nature of the definition of international arbitration, it became an international arbitration, then those matters became international arbitrations under the AFSA international umbrella. And a large number, interestingly, a large number of these are inter-African and Southern African arbitrations as well. So parties, you know, we've always said that it's crazy that if you have a dispute between parties and in Botswana and Namibia, that a dispute like that should end up in London. When it can just as easily be heard in Johannesburg or in some other Southern African seat. I think it's an important objective, I think, for all of us is to try and in our regions particularly to work on that, to increase awareness of the fact that we are well equipped. We've got the people, we've got the resources, we've got skilled arbitrators. And whether it's in East or West Africa or Southern African region, we've got all of this. So, and that's something that we all need to be doing. I'm just looking, I see there's one more issue that Yvette has raised again. If a foreign investor invests in Africa, then it is an African problem, and who better to arbitrate a matter than an African? A foreign arbitrator will apply the law from his viewpoint, meaning if arbitrators are involved in the outcome, the arbitrator will arbitrate the matter as such. If the manner of arbitration is that the arbitrator is nothing more than just an observer, then that will be the manner in which the matter will be dealt with. But I think we would all, I gather from this discussion, we would all agree that African problems and disputes should be preferably resolved in Africa and can be resolved in Africa. And we have the skill and the resources to do it in Africa. So I think on that note, unless anybody wanted to add anything more there, but we probably are running out of time. Anything else, anyone? Good. Well, thank you, everybody. Thank you for your involvement, and to our panelists for the contribution that we've all made. And I think that that was an interesting discussion, and I hope it leads to more communication between us on arbitration-related matters. I'm sure Stanley will be communicating with a number of you in future. And let's all keep in touch. Thank you.
Thank you.
Thank you. Thank you for organizing. Thank you, everybody. Bye. Bye. Bye.
Bye.
Bye. Thank you.